starting an enduring power of attorney on the MyDSS portal. So, you have set up your MyDSS account. Now, let's take a look at what you will see when you come to the MyDSS portal through your new account. First, you will see 6 tiles. You will need to click on Applications. From here, you will be brought to an Applications grid where you need to click on Start New Application. You will then need to select which type of arrangement you are applying for from the drop-down menu. In this case, you should click on Enduring Power of Attorney. From here, you will be brought into the Enduring Power of Attorney application itself. It will show you 5 steps. Go ahead and click on Step 1. Applying for an enduring power of attorney. Generating your documents. Step 1 online. As part of the first step for applying for an enduring power of attorney, or an EPA, on the MyDSS portal, you will need to complete your own details. You are known as the donor, or the person making the enduring power of attorney application. You will need to gather the following information before filling in your application: your name and address, your date of birth, your email address, your civil status and living arrangements, any relevant medical conditions or any communication and accessibility needs you have. We ask about this information so that the DSS is aware of your requirements as we engage with you in the application process. You will also need to tell us about your attorney's details. If you have more than one attorney, you will need to provide this information for each person. In an enduring power of attorney, the word attorney means a person whom you know and trust, whom you are choosing to make certain decisions if you lose capacity in the future. For your attorney's details, you will need the following information: your attorney's name, date of birth, and PPS number. Your attorney's email address. The email address you provide here must match the one used on your attorney's MyDSS verified account. This must be a different email address to the one you used to create your account. Please take care when entering your attorney's email, as it needs to be spelled correctly in order for the MyDSS message asking them to accept their role as attorney to be received. Your attorney's residential address. Your relationship to the person you have chosen to be your attorney. How long you have known your attorney. Whether you want them to be your main attorney or a replacement attorney. In this section, you must tell us about any other decision support arrangements you have. This includes any of the following: a decision-making assistance agreement, a co-decision-making agreement, a decision-making representation order, an enduring power of attorney, or an enduring power of attorney under the old Powers of Attorneys Act 1996, or an advanced healthcare directive. If you have one of these agreements, select Add Existing Arrangement to provide us with some details. If you do not have any existing decision support arrangements, you should select Save and move to the next section. Importantly, you need to tell us what types of decisions you wish to include in your enduring power of attorney. You must specify if you wish to include personal welfare decisions only, property and affairs decisions only, or both. You then tell us the authority you wish to give to your attorneys for each type of decision. This could be general authority for all decisions, or specific authority for one or more of these decisions. please refer to our website for extra guidance on this. You can also include any exceptions or conditions that you wish to apply. Once you are happy with all the details in your EPA, the supporting documents can be generated using the Generate Documents button and are available immediately for download using the download symbol on the right of each document. If any document changes are required, this can be done in real time by logging into your account and making those changes directly into the system. At step 1E, where you generate your documents, you must click Save and Return to Application to complete step 1 of the application. Before clicking Save and Return to Application, you may change any of the application details that were entered in steps 1A to 1D. If you do change any details, you will need to regenerate your documents so that the changes are reflected in those documents. When you are sure that all details have been entered correctly, you must click Save and Return to Application, which will trigger a MyDSS message to be sent to your attorney or attorneys asking them to accept their role. Attorneys must respond to this message before you can submit this application. Please note, once you do click Save and Return to Application, you can no longer add any other attorneys to your application. These documents are unique to you, the donor. They are pre-filled with your application information and will have blank sections to be filled in where needed. To ensure that you are on the right track, the documents that will be generated are the Enduring Power of Attorney Instrument Template, the Donor Declaration, the Legal Practitioner Statement, the Statement of Capacity, the Attorney Declaration, and the Notice Form. When you complete each stage, a green tick will appear against the application step to show you that you have completed that stage. There is also an application progress bar at the top of this page to show you how far you've progressed with the application. At any stage, you can leave and return to the application in your portal account. Applying for an enduring power of attorney, completing your supporting documents. Legal Practitioner Statement. As we have seen, a number of documents need to be completed as part of this application. The first of these is a legal practitioner statement, which must be completed by a practicing barrister or solicitor to include the date of interview, and the statement must be signed and dated. It is important that the solicitor or barrister's contact details are provided in this statement. We provide samples of what this legal practitioner statement looks like on our website. Applying for an enduring power of attorney. Signing and witnessing your enduring power of attorney. The enduring power of attorney must be signed by all parties. That's you, the donor, all of your attorneys, including any replacement attorneys, and 2 witnesses. Now, it's important to remember here that there are some rules when you are signing. You and your attorney or attorneys must all sign at the same time and in front of the same 2 witnesses. It's also important to remember that your witnesses must be 18 years or over, at least one of them cannot be an immediate family member of you or any of your attorneys, and they cannot be an agent or an employee of any of your attorneys. Just to be clear, an immediate family member means a spouse, civil partner, or cohabitant, a child, son-in-law, or daughter-in-law, a parent, step-parent, mother-in-law, or father-in-law, a brother, sister, stepbrother, stepsister, brother-in-law or sister-in-law, a grandparent or grandchild, or an aunt, uncle, nephew or niece. Applying for an enduring power of attorney. Your statement of capacity. Getting a statement of capacity is important as it demonstrates that you had the capacity to understand the implications of making an enduring power of attorney at the time you executed or signed the document. This document must be completed by a registered medical practitioner or another healthcare professional after you signed the enduring power of attorney, as this date will need to be put into your statement of capacity by the person who undertakes the assessment. Other healthcare professionals are an occupational therapist, a registered midwife, a registered nurse, a social worker, or a speech and language therapist. None of these healthcare professionals can be your immediate family member. Just to be clear, an immediate family member means a spouse, civil partner, or cohabitant, a child, son-in-law, or daughter-in-law, a parent, step-parent, mother-in-law, or father-in-law, a brother, sister, stepbrother, stepsister, brother-in-law, or sister-in-law, a grandparent or grandchild, or an aunt, uncle, nephew, or niece. We call the medical practitioner or other healthcare professional who provides your statement of capacity the assessor. It is important that the statement of capacity is fully completed by the assessor. This means that the date the EPA was executed, signed by all parties, the date of assessment, and the date the statement is signed are all included in this document, as well as the assessor's details. But the most important thing to remember here is that this document can only be done after you, your attorneys, and your witnesses all sign your EPA document. If the capacity statement is done first, then you will need to provide another statement of capacity. Applying for an enduring power of attorney. Giving notice. So once you have signed the EPA and have all the supporting documents completed, you must tell or give notice to certain people. There is a list of people in the Act that you are required to give notice to. These people are your spouse, civil partner, or cohabitant, your adult children, if any, including stepchildren, and any other decision supporters you have. Now, if you do not have at least 3 people from this list, you must also notify 2 other people of your choosing. This could be anyone else you wish to specify as a notice party. You must give a copy of an EPA template, the signed declarations, and the notice form to each notice party. Any of the notice parties have 5 weeks to object to the registration of the agreement. There are specific grounds on which an objection can be made. Further information on this can be found on our website. If we receive an objection, we will review it. If we believe there are good grounds for the objection, we may refuse to register the enduring power of attorney. If we receive any valid objection, we will tell you about this and keep you informed of the process. You will also be invited to give us any information about the detail of the objection as part of that process. Applying for an enduring power of attorney. Uploading your documents. Once the documents have been completed, you can then upload all your completed and signed documents through your MyDSS account. As a reminder, these documents are each attorney's signed and witnessed declaration, to include any replacement attorneys, your own signed and witness declaration, the enduring power of attorney arrangement, the completed and signed legal practitioner statement, and the completed and signed statement of capacity. Applying for an enduring power of attorney, witness details, notice parties and payment. Step 3, 4 and 5 online. Once the signed documents have been uploaded, there are a few important final steps you must take. You must provide the details of the 2 people who witnessed you signing your own declarations. Please note that the date witnessed that you enter here will determine the execution date of the arrangement. It is within 3 months of this date that you must submit your application. As we mentioned, you must give notice to your notice parties using the notice form provided. Please refer to the section on giving notice if you need more information. You must provide the details of the notice parties you notified of the arrangement. This is step 4 online. And finally, you must pay for the application at step 5 online. Applying for an enduring power of attorney, attorney approval, DSS review, and objection period. Once the application is ready to submit, the final step is for the attorney or attorneys to accept their roles. This can be done by logging into their own MyDSS account and replying to a MyDSS message that would have been automatically sent to them. Once this is done, the application can be submitted from the Donors Portal account. Once your application is submitted, the Decision Support Service makes sure it meets all legal requirements. As we mentioned, there is also a 5-week objection period, which allows people to raise any concerns before the arrangement is registered. Once your application has been reviewed, and if it is approved, you will get a certified copy of your arrangement. This looks like the arrangement template you give to your legal practitioner, except it contains extra information to confirm that the arrangement is approved. At this point, the arrangement sits with the status of registered until a time in the future when it may be notified by one or more of the attorneys if you lose capacity. Notification of an enduring power of attorney, activation, the register, and attorney reporting requirements. So, your EPA is registered. Now, what happens at a time in the future if you lose capacity in relation to one or more decisions? Well, if that happens, then the EPA that you've put in place to manage that situation can come into effect. Your attorney must notify the Decision Support Service. Your attorney must provide 2 statements regarding your lack of capacity, and your attorney must give notice to the notice parties. After this, there is a mandatory 5-week period during which the notice parties may raise objections. Once notification is accepted by the Decision Support Service, the EPA is activated and the attorney or attorneys have the legal authority to make relevant decisions on your behalf as set out in the EPA. The notified EPA is included on the Decision Support Service Register of Decision Support Arrangements. The attorney or attorneys will then begin the process of reporting to our supervision team. This will include submitting, within 12 months and annually thereafter, a report to the DSS in relation to performance of functions and other reporting requirements, depending on the sort of decisions the attorney is authorised to take. If your attorney is appointed in relation to property and affairs decisions, then the attorney also has to submit an initial report to the DSS after 3 months, setting out a statement of your assets and liabilities and income and expenditure. Information for attorneys about reporting duties is available from the DSS.